Hi, this is Unit 4 of A-Level Law. My name is Max, and today we're going to be discussing theft. Section 1 of the Theft Act outlines that for a defendant to be liable for theft, they have to dishonestly appropriate property belonging to another with the intention to permanently deprive. It sounds like a lot, but when you take it through sections, it becomes a lot more digestible. The mens rea of theft consists of dishonesty, which is outlined in Section 2 of the Theft Act. There is no legal definition for dishonesty, but there are 3 circumstances where a defendant can be considered not dishonest. These are where the defendant believed they had a right in the law to deprive another of their property, where they took reasonable steps in order to find the owner, and where they had the owner's consent. For example, Robinson is a case where the defendant had an honest belief he had a right in law to permanently deprive another of their £5 because he believed he was owed 7. Small is a case where the defendant decided to keep a car because he couldn't find the owner through taking reasonable steps. If the defendant still believes that their actions were not dishonest, then the ghost test is applied. The first part of the ghost test asks whether the defendant's actions were dishonest according to a jury of honest and reasonable people, and the second part asks whether the defendant was aware that his actions fell below those standards. The court ruled in IV v. Genting that they would not apply the second part of the ghost test to theft cases because, interestingly enough, most defendants believe they're innocent. Therefore, only the first part of the ghost test is considered. Section 3 of the Theft Act is defined when a defendant assumes any one of the rights of the owner. For example, Pit, Ham and Hell is a case where the defendants try to sell off the furniture of the owner who was in prison at the time. It doesn't matter whether they actually sold the furniture or not, only that they assumed one of the rights, which was to sell off the property. Morris is a case where the defendant switched the prices of items at a store in order to buy the item at a lower price. This case also establishes that the defendant only needs to assume one of the rights of the owner, and not all of them. Section 4 of the Theft Act concerns with property. This includes money and all other property, such as real or personal, things in action, and other intangible property. Real property refers to land and anything fixed to land, such as houses and buildings, and personal property refers to anything other than land. So this may be prohibited drugs, such as in the case of Smith. Corpses are generally not considered property, but body parts may constitute as property, such as in the case of Kelly and Lindsay. Things in action refers to personal property rights that can be legally enforced, such as a patent or a debt. And intangible property refers to property that has no physical existence, such as a domain name. Oxford v. Moss is a case where the defendant took information from an exam booklet, but not the actual booklet itself. Therefore, information or knowledge cannot be considered intangible property for the purposes of theft. Section 4, subsection 3 of the Theft Act states that a person will not be liable for theft if they have picked up any wild mushrooms, flowers, or foliage, unless they then try to convert it for personal gain. Section 4, subsection 4 of the Theft Act also states that wild animals cannot be stolen unless they have been tamed or owned by another. Section 5 of the Theft Act defines that property will be regarded as belonging to any other having possession or control of it. So this means that a person can be liable of stealing their own car if it is in the possession or control of another, such as in R.V. Turner. Section 5, subsection 3 of the Theft Act also provides that where property is given to a person with instructions to deal with in a certain way, the ownership of the property remains with the giver. For example, in David v. Bennett, the roommate gave money and specific instructions to the other person to pay for the gas bill, and instead they bought Christmas presents. This was held to be theft because they had a legal obligation to pay for the gas bill. R.V. Hall is a case where the defendant, being a travel agent, received money from the client for their holidays. He paid this money into a general account and therefore wasn't liable for theft when the business collapsed because he had no obligation to deal with it in a particular way. If property is truly abandoned and it has no owner, then anyone who takes the property will not be liable for theft. However, there may be difficulty in trying to ascertain whether the property was truly abandoned. Lost property is still regarded as belonging to the loser of the property. However, if the owner cannot be found through reasonable steps, then the finder of the property has better title to the items found than the owner of the items. Section 6 is the intention to permanently deprive. Under this section, a person is treated as having the necessary intention to deprive if they treat the property as their own, regardless of the owner's rights. This section also covers borrowing in circumstances making it equivalent to an outright taking. In Lavender, the defendant took a door from a council house to replace a damaged door in his girlfriend's property, which was also owned by the council. This was not theft, however, as he had no intention to permanently deprive the owner of the property. So next time, we're going to be discussing robbery. See ya.